You're going to now get me to reveal my thoughts on things that will get me expelled from the Club of Law Professors. In speaking not to law students, I always remind people to think about what the Constitution is, what the United States Constitution is. What is that? That's a document that creates a strong national government where there wasn't one. Libertarians or classical liberals like to appeal to the Constitution as some kind of bulwark of liberty. That's just wrong. The Constitution is the creation of a strong national government with power that didn't exist before. There's a part of the Constitution that people like to mention, which are the first 10 amendments called the Bill of Rights. But every one of those is a provision that says what the government that they just created can't do. Right. The Constitution creates the problem, and then they have to create a Bill of Rights to solve the problem they just created.
John Hasnas is a professor of law at Georgetown University. He wears many hats there. But as an author, his newest book, Common Law Liberalism, is on my holiday wish list. John Hasnas, welcome to the show.
Thanks very much. Thanks for inviting me.
Oh, it's my pleasure. I admit that I've been greatly influenced by you. I love the way you think, and you've certainly helped shape my thinking. So I want to share that with the Underthrow audience today. And we can start with your deep affinity for the common law. Does that sound good?
Well, that's my field. Yes, that sounds good.
Excellent. So the way I see this, and correct me if I'm wrong, but I imagine much of the world, especially the West, has been fought over and in many ways covered by two basic different types of law, at least in the West, right? Statute law on the one hand and common law on the other. You might call it Justinian law, this sort of legislature-made law on the one hand, and common law, which is, more about, aggregations of judges and peers making law through precedent. And if I got that in any way wrong, let me know. But the way I see those two different types of law is sort of battling it out throughout history and through time. So help us understand these two types and why you prefer one of them over the other.
Okay, that's an interesting way of putting it. And you're right. To get started, I probably should describe what I'm talking about when I'm talking about common law and what the difference is between common law and statutory law. And if I do that well, then I can comment on whether they're actually battling each other or whether it's been a completely one-sided war. At any rate, common law is where law starts. So nobody comes into the world with a government already existing. People have to learn to live together peacefully in order for there to be society, in order for people to progress. And law originates in the kind of practices that allow people to cooperate. So there'll be some kind of conflict. There are many ways of settling it. Some are tried and don't work, so they're not repeated. Some are tried and work. People understand that's a good way of resolving conflicts. They repeat it, and over time, a practice develops. As you get from primitive societies into more advanced societies, the kind of what's ordinarily called customary law, customary practices that allow people to peacefully interact and cooperate, get repeated, and they become rules. And at some point, you may get to the point at which the rules become enforced by certain agencies. So in English history, what happened was after the Norman conquest, when the Norman kings became the enforcers, the customary law of England started to be enforced in royal courts. And those courts are what are called the common law courts. So the law of England and of the United States that governs most of our interaction, which is contract law, tort law, which is personal injury law, property law. All of those rules evolved over time because they help people cooperate and settle disputes. And they became enforced in the royal courts. And that meant that they were spread throughout the entire realm, and they were the common law, the law that's common to the realm. As you get closer and closer and closer to the present, the legislatures make more rules. So Parliament could make law. That's statutory law. In the United States, the state legislatures make law. The federal government makes law. That's politicians consciously making law by passing statutes, and that's statutory law. So that's sort of the groundwork. You said there's been a battle between them. Um, that may be a correct way of expressing it, but it's been a very one-sided battle. And the reason is that statutory law can always replace common law. So whenever a political entity, whether it's parliament or state legislatures or federal legislature, decides to pass a statute, that statute replaces whatever the underlying rules of common law are. So statutes always win. Now, whether or not that's a good thing is something that I write about. But at least between the two of them, the politicians always have the upper hand, and common law will fall to any new statutory measure.
So we can imagine a world where really statute law predominates. It's sort of
That's the world
covering
we
more.
live in. That's the world we actually live in.
That's the world we live in, right? I mean, there are vestiges of the common law or this customary law, but what would the world look like if we were to revive it, or it achieved something of a renaissance? What would that look like?
That's a great question, and my answer is going to seem counterintuitive. But it would look like the world we currently live in with a lot less strife. So why? Contract law evolved over many years. Contract law allows people to cooperate, businesses to succeed, prosperity to be achieved, and that's still the way it is. Contract law came from common law. It works well. Tort law, which is the law governing personal injuries, over a long period of time, we learned how to provide compensation when people behave wrongfully that produces a certain level of peace. That works. Like the underlying common law is what allows us to cooperate. Statutory law has increased from the 19th century to the 20th to the 21st century, so that we live in a world that's rife with statutory law. But statutory law often doesn't help cooperation, but creates strife. In other words, a statute can be something that in a divided government, one side passes that the other side doesn't agree with. So should abortion be against the law? There's a division on that, but if you pass a statute on it, then half of the people who disagree think that there's something wrong. The present is a pretty good illustration of the kinds of divisions that come out of the political process, where one side's passing laws that other people disagree with. And political strife is a result of a battle for control of the political mechanisms that create the law. So we live in a world in which the underlying law that allows us to cooperate was common law, came out of the common law, that still exists. That's what provides a peaceful, productive society. The other part of our law, which is statutory law, sometimes it's perfectly fine. Sometimes it helps people cooperate. Sometimes it's not objectionable. But in most of the controversial cases, whether it's abortion or political, freedom of speech, these kind of issues, it doesn't provide cooperation. It's one side trying to suppress the other, and that's where the political strife comes from. So that's a long answer. The answer is, if we didn't have statutory law and we could revert to a common law system, what would the world look like? And it would look like it looks now without the political strife that overlays the way we act.
So in a manner of speaking, or even quite literally, It's almost as if you're focusing on the means of cooperation, as you said, but also frictions. So if we have a disagreement about the use of my property versus yours, or over a contract and how to interpret that contract, and so on, those frictions are to be decided in some sense by third parties rather than some sort of distant legislator with the notion of the one true way. Is that more how things, and can there be some variability with the outcomes that creates a patchwork of legal frameworks?
Yeah, I agree with everything you're saying.
Okay.
It's just that we're speaking at too abstract a level now, which is a danger for people like me with a PhD in philosophy.
Okay.
But uh, what would probably be more useful would be to bring it down to a more practical level and provide illustrations. So let me
Right.
illustrate what the points I'm trying to make with discussion of tort law. Tort law is what I teach at Georgetown. It's a personal injury law. How do we know what rules we need in order to interact peacefully? Maybe I'll use this as an illustration. I teach from a traditional case book. It's been used for years. It's a great case book. It has cases from the 19th century, the 20th century. It's wonderful. But a lot of the cases in the torts case book are about railroads. Students always say, how come there's so many cases about railroads? And the explanation is because at one point in time, railroads were new technology. They were making the country more connected. They were creating prosperity, but it was new technology and we didn't actually know how to use it safely. And so conflicts developed. There would be they would cause a spark would cause a fire. Somebody would suffer damage. What should we do about this? Well, lawsuits developed and the lawsuits resolved the case. The lawsuits that are in the casebook are the ones that resolve things successfully. And over time, they became the rules governing railroads. And now in the casebook, there's almost no more cases governing railroads. But in the 1990s, there was a new technology, new reproductive technologies. Now it's things like AI is going on. We have new technology. We don't know how to use it safely. The typical approach to issues like that is to go to politicians and say, make some rules. But they don't know any better than we do. In fact, they're probably influenced by considerations other than what would be the best rules. But if you allow lawsuits to evolve, that's how we learn what rules work best under stable. We're not smart enough to make rules that will allow people to cooperate in advance. We're just not smart enough. There's too many possibilities. We don't have the intellectual capacity. This is sort of a Hayekian point. But the way we learn about what law should be is through a trial and error process. Here's something that causes conflicts. One state tries to resolve it, bad resolution. Another state tries to resolve it. There's a lot of cases. A state comes up with a resolution that's stable. Everybody copies it. That becomes the rule of law. Trial and error learning creates law just as much as it creates market success.
Forgive this brief interruption, but I suspect you're here because you're disillusioned with legacy politics. If you're a creative, a builder, or an innovator, you might be ready to win funding. Through Human Respect Labs, you can get up to $30,000 to fund your next creative project. But not just any project. We're looking for 6 kinds of builders: video storytellers, community builders, writers, entrepreneurs, strategists, and innovators, any of which should be dedicated to human liberation. That means making government obsolete. Why? We know too much energy goes into politics, but not enough goes into real solutions. So if you're a freedom lover and you have a project idea that promotes peace, autonomy, and voluntary collaboration, we want to hear from you. Apply now at humanrespectlabs.org. That's humanrespectlabs.org. Criticize by creating. Does it count on that process that I guess you could call it a coalescence around one of the stable decisions. Sometimes you get results in certain kinds of cases that are more a reflection of culture and morality or differences in people's cultural or moral priors than you might in, say, what is a stable equilibrium or a stable outcome. Does common law allow for that variety or that diversity in, let's say, one just jurisdiction versus another,
Yeah,
or in yeah, just one standard of law versus the other?
yeah,
How does that work?
yeah. It depends on it. And
Yeah.
common law depends on diversity, on variety. Common law is about settling this. Common law only exists when there's conflict, when there's disputes. If we're cooperating perfectly right now, we don't need rules. We cooperate. Something happens. You're upset with the way I behave. I think that you're doing something wrong. We have a conflict. What do we do about it? We need a resolution. Common law is the law that arises out of settling disputes. And the way you settle disputes, we're human beings, we do it by trying different solutions and repeating the ones that work and not repeating the ones that don't work and create more strife. And we learn in this way. At common law, it depends on variety. It's not stable. Like if you have a very distinct theory of justice, then you're not a supporter of common law because the common law is not going to embody any theory of justice. It will depend on our background, cultural beliefs, and things like that. It will be as advanced as our society is in some sense. It's a little ahead in the sense that it always results in something that produces a peaceful rather than a violent resolution. So it actually,
Why does it?
yeah, because if it's a violent resolution, people keep fighting and it doesn't work. Right? Uh,
What if it's just an oppressive resolution?
yeah, it's possible. It's always possible that a common law system can provide unjust results. It can provide unjust results in particular cases. Sometimes wrong, sometimes unjust, and that's the nature of human beings. If you're in that kind of culture where the interaction of human beings culturally is very oppressive, imagine the alternative. What if you took some people in that culture and said, okay, you're in charge, go make the rules? The common law didn't evolve by itself segregation. Remember, segregation of the races had to be implemented through legislation. If the common law was good at segregating the races, we wouldn't have legislation. If the common law is only as good as your culture, but in a situation like that, the only alternative is to give some part of the culture power. And when you have people with legislative power, they tend to favor their interests over others. So once again, in the real world, you're only making comparative choices. By the way, if you come up with a way of making sure that whoever makes the law only makes just law that's always right, then I'm for it. But in the real world, that's not one of our options.
So part of this I hear are a set of assumptions about what lies in the background, right? What lies in the background of our thinking? If we are judges, juries, how the juries are instructed, where I can imagine us in an arbitration hearing, right? Where we agree sort of outside of the auspices of public law to settle our disputes with an arbiter or something like that, a third party that
Yeah.
we both agree to. We want for that arbiter to have some sense of justice, where justice is that the injured party is going to receive some sort of compensation, or there's going to be acknowledgement of the injury, rather than that the arbiter would say, oh, well, this is, for example, an intergenerational payback that you have to pay because your forefathers did something, or something like that. Let me put it this way. You have argued in the past, I think quite successfully, that the rule of law as such is kind of a myth. Um, Another way one might put this really gauchely is that interpretation is a bitch. And no two people are going to interpret things exactly the same, or at least it's very difficult to reach that level of unanimity with a group of human beings, even a culturally similar group. How is it that the sort of the background considerations or the priors evolve with the common law? Because there are certain things, certain kinds of cultural tenets that we expect of our judges and our juries and so on. How do we get to those? Is that also co-evolve with the system?
Okay, your questions are very thought provoking. So they've provoked some thoughts on me, but I'm not sure they're entirely responsive. So the first thing that came to my mind is an analogy. So
Mhm.
stepping away from the law, imagine you're talking about markets and businesses. So people want to have effective mousetraps, and others think I can make some money if I sell some mousetraps, and they devise a mousetrap, and it's terrible at catching mice. Uh, that business goes out of business. Another one has another mousetrap. Maybe it's a little bit. The company that survives is the one that makes the mousetrap that's most effective at the lowest cost. And there might be 100 other mousetrap companies that disappear. And what we learn is this is a good mousetrap. There's nothing about the individual efforts of any of the businesses which require inordinate wisdom. I think this is accurate. The first pizza delivery company was Domino's, and the guy just came up with his idea, and it was so good everybody copied it. That's the way markets teach us what the best product is. The same feature works in law if you're talking about the way common law evolves. I have to make this clear. The common law will not embody any theory of justice. If you're an intellectual, if you're a philosopher, whether you're a libertarian or you're Marxist, you're not going to get that out of the common law. It won't embody that. What it will do is it will tend to capture the rules that have been tried that actually allow people to cooperate. It nudges us in the direction of peaceful cooperation without embodying any cultural or philosophical theory of justice or anything else, because it's a learning process that's not directed by any intelligence. That's why the common law is so unpopular. Why do politicians say we have to pass a statute? Because the common law, the rules that are developed by themselves, don't embody whatever their theory of the just society is and has to be corrected. The common law also always has to be corrected because it's never ideologically correct. It's never pure. It's never embodying what they think the right answer is. It's just something that allows people to cooperate. And if you're like me and you advocate for the common law, what you're basically saying is, if you have a society that's good enough, don't destroy it by going for perfection. Right? If you want to have a law that embodies any theory of justice, it's going to have to be oppressive unless everybody agrees. And there's very few large societies in which that's the case. So the common law is like a learning process, like the market, where lots of things are tested. The ones that allow us to cooperate peacefully are the ones that survive. And over time, it gave us the commercial law that we function under, the property law that we function under, all of the law that lets our society be as prosperous as it is, was not made by any conscious intellects. It evolved because we tried things until they worked. The law merchant was an international law that evolved entirely to allow people to travel back and forth and trade without fear of being exploited when they were in a place that they didn't come from.
The Silk Road or whatever.
Okay, it could be, but the
Yeah, I mean,
merchant,
it's like I can imagine all these merchants. Lex Mercatoria is like a,
yes,
it's the submergent law of basically trading partners who may never encounter each other again, but they don't want to get ripped off. They
Yep.
want to make sure that the trades are that they can continue to ply their wares along the Silk Road or whatever, the Mediterranean Sea, or wherever it is. Um, but it's the accretion of the merchant law was written down in a context not of I've got this theory of justice, I'm going to write it down, but rather more this is what we have. It's sort of snowballed through time, good decisions about how to resolve these disputes. Is that
Yeah, you're right in two respects. Right. The first respect, in fact, the merchant law that evolved across the continent in England was so effective that in the 18th century, Lord Mansfield just said, "We're taking this and making it part of we didn't need the common law to evolve commercial law." The One of the law lords, Lord Mansfield, just said, "Okay, this is so good, we're making it part of the common law." It evolved in that way. But the other way in which you're right is it's not law that was written down. If you want to understand our legal history, you have to understand that there was very little, there's no printing, there's very little writing. Most of these things are oral exchanges. It is true that we have accounts of things that are written down afterwards, and very sophisticated professors who can speak Latin and go read the plea rolls and things like that can find out what it is. But this was a system that had to function with a much lower level of literacy than is presently the case. That's why it's customary law. What did people do? What worked in the past? What can we learn from this? It gets repeated and repeated and repeated. And as time goes by, it ends up getting written down. But originally, it's not that. It's something that people understand allows cooperation, and the knowledge of what works spreads.
okay? So this is really interesting. This goes all the way back to all of our notions. You mentioned Hayek before. Our notions of emergence, almost like you can compare it to biological emergence. Of you have these little fragments of molecules, and some have the sort of implicit rule turn left, some have the implicit rule turn right. They call it chirality, I think. And they encounter each other, and they either bond or they bounce by virtue of these properties, and they become more and more complex as time goes on. So you get this sort of accretion, and emergent complexity results. That is a level of abstraction that listeners might not be comfortable with, but it is at least an analogy that lets us appreciate the full emergence value of the common law, if you can tolerate that phrasing.
My kids ask me what I do for work, and I say, I write, talk into a microphone, and hope people send money. Now I'm questioning my life choices, but the kids gotta eat, and we have bureaucracies to topple. Support our work at underthrow.org, and for less than $5 a month, you'll help me rouse the rabble. Wait, what's underthrow? If overthrow is violent, underthrow is peaceful yet powerful. Real change doesn't start in Washington. Casting your vote with millions is like crying a teardrop into the ocean. Instead, we build consent-based communities that make traditional power structures obsolete. Left, right, or center, it doesn't matter. What matters is creating options for opting out and opting in. We build parallel systems in which people thrive, then just leave the old systems behind. It's about choosing communities, not imposing them. So, support the show, feed my kids, read the newsletter, and discover why most subversive acts amount to building a better civilization together. Visit underthrow.org.
So I'm thinking of so I want to share something that happened to me, and this appealed to my inner philosopher, my inner theory of justice, right? And that was an invitation by someone to run a contest. But I'd always thought about this, and I'd thought about it because I'd been involved with some of the projects in Honduras with the ZEDES legislation, where they were meant to set up a jurisdiction, and they wanted very quickly to have some sort of commercial law, some sort of regulatory framework, and so on. So they were a bunch of guys who were, you know, you might say old Whigs or liberals or something like that. Liberal in the sense of concerned with freedom and cooperation, as you seem to be. And they set up Prospera, which is this pretty darn good and successful jurisdiction within the context. Now, it's not its own state, mind you, but at least it is a proof of concept that you could have a legal carve out for commercial law and leave other kinds of law to the state of Honduras. Okay. Now, they needed to do something to sort of to get this going. So there are two embedded questions here, and maybe I'll take them in turn, and we might forget one of them, but that's okay. The first is, how would we go from here right now in the United States from a condition that is so dominated by statute law, by legislators and interpretations of legislation, to a condition where we have this customary law, whole cloth? Another way of putting that is, if we were going to, let's not talk about how we get from A to Z within the context of this current state of affairs, although I think that's quite useful and important if we want to make such a transition. We can at least think about jurisdictions that are carved out or not yet captured so by favor seekers and interests, like setting up a jurisdiction similar to Prospera. So that's an easy case. Changing America from a statute regime to a common law regime or customary law regime is a really, really, really hard case. So do you want to start with the easy case or the hard case?
The reason why I'm smiling at your question is because my degrees are law and philosophy, not political science. Whenever I speak, I start out by saying, if you want to know how to make a transition in the real world, then I don't have expertise. What I can do is I can try to convince people that you can have a successful, prosperous society with very little legislation. I'm going to say no, without legislation. And I can paint a picture of what it would look like and why it would work. If you want step-by-step instructions on how to do it, I have no particular expertise. I will say some things that are perhaps suggestive, and it means you have to go back and think about the 1990s. Right? There's no direct way of shrinking power. But in the United States, not anymore. In the United States in the 1990s, progress was made, and that's because from 94 until 2000, there was divided government in Washington. For example, if you can remember the 1990s, one of the big issues was we have to have tort reform. We have to have tort reform. The people can't make playgrounds anymore. You can't manufacture football helmets. The tort system is ruining everything. We have to have tort reform. The Democrats wanted tort reform. The Republicans didn't. There was divided government. They couldn't legislate on the topic. And then by the year 2000, tort reform was much, much less important. And the reason is because over the time period, enough cases had made their way through the system, and there had been 2 Supreme Court decisions that dealt with what used to be called the problem of junk science in the courtroom. With the system not interfered with by the politicians, but working itself out, that problem was solved. So if you can stop the government from doing things long enough by having it in gridlock, then the common law, which is still there underneath, can resolve some problems. If you want to actually make progress, you have to figure out how to gridlock the government for the indefinite future. Right now, we have a perfect example of what happens if one side controls all the levers of government power, which is it does what it wants. Before this administration, for a while, the Democrats had control of all levels of power, and it started to do what it wants. There's no way out of that. Unless you have to gridlock the government, you have to have some kind of monkey wrench system. If you can do something to paralyze the people who are trying to wield power, the underlying system can work. That's not really a very optimistic prescription for making progress.
Oh, I remember where I was going with this, and I apologize now, but your answer, with all humility that we found in it, I mean, you did give us a nice picture of the 90s and how gridlock essentially gave us a series of cases that resolved some of the issues that the legislatures couldn't, and that's an interesting phenomenon. What I was getting to was someone had asked me to run a contest to develop a constitution, a certain kind of liberal constitution. And having already encountered your work, I was a little troubled by that. Not because a constitution is essentially a statute. It's a great big statute that allows you to move a lot of earth on the basic parameters of what it means to be a country. So I begin to think about this separately, and I give some hints to the contestants, and I won't go into the results of that contest and some of the contributions. But one of the things I discovered was that I imagined the idea of multilateral contracts, where a constitution is really, when people is really just a social contract, but one that you literally sign. By virtue of being a signatory to this massive multilateral contract, you essentially agree to the auspices of these countries' rules. And then out from that, perhaps, could flow more common law or customary law, but the very basic sort of idealized features that one might want to see in a constitution are there. I wonder if you might be skeptical of this as an approach, because a constitution is a constitution and it might be too rationalistic for your perspective, but I don't want to put words in your mouth. What do you think about that?
Those are the right words to put in my mouth.
Okay.
Skeptical, yes. Skeptical, I think it's a terrible idea. All right, so you're going to now get me to reveal my thoughts on things that will get me expelled from the club of law professors. In speaking not to law students, I always remind people to think about what the Constitution is, what the United States Constitution is. What is that? That's a document that creates a strong national government where there wasn't one. Libertarians or classical liberals like to appeal to the Constitution as some kind of bulwark of liberty. That's just wrong. The Constitution is the creation of a strong national government with power that didn't exist before. There's a part of the Constitution that people like to mention, which are the first 10 amendments called the Bill of Rights. But every one of those is a provision that says what the government that they just created can't do. Right. The Constitution creates the problem, and then they have to create a Bill of Rights to solve the problem they just created. Constitutions create power. That's a terrible way to go to a system in which you have peaceful, free interaction among people and more liberty. What you want to do is shrink power. If you grow up in the United States, I don't know if you grow up I don't know if it's still true, or I don't know if kids learn anything anymore, but if you grow up in the United States, the one thing that you learned was that the founding fathers adopted the Constitution. Why? Because the Articles of Confederation failed. We're all taught that. Think about it. That's entirely wrong, right? The Articles of Confederation succeeded wonderfully. They required unanimity for anything to be done as a way of making sure that there wasn't too much power. It was so hard to use government power to force people to do things under the Article of Confederation. They were so successful that they threw them out and created this new national government, which had a lot of power to force people to do things. What the way we're taught is exactly backwards if you're really interested in a market society. Constitutions are always a bad idea. Now, lots of my libertarian friends, and this may get into something that's more in line with my work. Lots of my libertarian friends just think, well, the social contract is nonsense because nobody actually agreed. What we need is real contracts where you actually agree, and then you're bound. And yeah, you'd be bound if you agreed. And there's no society that's ever like that, and there never will be. And it's impossible to get something like that. In small clubs, you can. Common law is not law by consent. It's not that kind of libertarian mirage of rules that we agree to. It's actually binding coercive law. It's just law that wasn't created intentionally by any people with power, but arose in order to solve problems. It's binding, it's law, it nudges us in the right direction, it doesn't ensure justice. It's just the best we can do given our limited knowledge and our inability to predict what's needed in the future. Now, we're all so impatient with that. Nobody wants pretty good law. Nobody wants a pretty good system. Everybody wants to make it better. But the only way to make it better is to give some people power to make the corrections. Some people have the legislative ability to make the common law better. And once you've opened that door, that's how you end up with all the oppressive rules that favor one side or another. There's no way to prevent people with power from exercising it in the way that they believe is right, even if it's not universally accepted. So
So
don't
how do you establish it? I mean, it
establish.
evolved in Anglo-Saxon, Britain. It was sort of adopted by the Normans and integrated into their slightly more centralized system, I guess. Isn't that right?
I'm not sure if historically speaking, like the Normans were amazingly effective innovators. They were really good at centralizing power. But when the Normans took over England, it still took them centuries to monopolize the law. I mean, the Magna Carta was famous. It's a struggle between the crown and the barons over who makes the rules. Parliament versus the history of England is a long history of the crown trying to centralize power and getting it away from the lower elements. Remember, the common law was the law of England, even though there was a lot of control in some ways, that still was law that arose from settling disputes. The way the common law arose was if there was a kind of dispute that wasn't covered by the rules, people had no solution. They would go over to the court, the chancellor, and say, I need a solution. And there would be an equitable provision that was suggested. And then when the common lawyers saw the business going over there, they said, well, wait a minute, we got to get the business back. They started making rules. It was like a little market for law, especially since the different benches collected their fees from the litigants, that kept the law responsive to what ordinary people needed. Only statutes could favor the politically powerful, the dominant, whichever group it was. That's why the history of statutes is a history of strife and struggle, and the common law is just what allows people to cooperate. That's a digression. I'm not someone who thinks constitutions are a good way to go because I don't think we should be creating centers of power.
I absolutely agree with you. The way I tend to think of it, and I don't have your legal mind, so my thoughts on the matter are theoretical, and that comes with its own problems, as you know, being a sort of legal mind and a philosophical mind. But I do wonder, in very real terms, and there's a pragmatist in me who thinks, okay, well, we think about human interactions around the world within various groups over time through millions of iteration cycles. And the closest thing we ever got to the common law was in Britain. There's some strange Icelandic law that has these kinds of features, and I think maybe in Ireland, and all these are fairly proximate. In other places, you essentially get protection rackets, where the biggest, meanest guy essentially makes the law by fiat, and you create these hierarchies based on that. If you have law at all, which would be fiat law, and that would be, Hammurabi's code or something like that at best for that kind of stuff, or you get Roman style law. So the hope that just having people come together and interact without any sort of protocol design or some sort of theory of law backing it up seems to me to invite all these different iteration cycles that have suboptimal results, assuming that I agree with you that the common law is the way to go. But the way I hear it from you is that the only way it can be is completely emergent.
Okay.
Am I wrong about that?
Um, no, but I may quibble with your depiction of history. Here's what I mean. The customary law, the common law, some version of that exists, always exists. The reason why so many legal scholars still study Roman law is because Roman law was a wonderful example of how rules come out of cases and dispute settlement. You're right. It is the case that at some point, the entities with power, the governmental entities, take over because that's what you can do with
They
power.
can.
Yeah. Yeah. But there isn't a society unless it's started in a different way. It can be England. The reason why everybody talks about Iceland and Ireland is because we have these records of the saga, and also because David Friedman loves it and he talks about it all the time, and he wrote a book on it. But
Right.
it's fairly universal. It's not just England. When I was growing up, we would study the Israel in the time of the judges. There's the story of the Bible, and there's this long period called Judges. What was that? That was a time when there was no government, and actually things were settled by people coming to someone who was deemed to be wise and making decisions. We had a long history of rules evolving back then, and the reason why it's unknown, the reason why nobody talks about it, is because it worked and there wasn't strife. Right? History is the history of warfare and strife and struggle. If things are working well, there's no history. And that's why when we think about how governments behave, it's always bad governments behaving, right? We don't actually hear much about what's going on in Switzerland because things are fairly peaceful there and they're working well for some reason. We should probably study that, but we ignore it. I just lost you. Are you still there? Yeah. Yeah. So we should probably focus our attention elsewhere. But the problem is a practical one. We get good rules when they evolve. How do you stop people from taking coercive power and creating a lot of bad rules and creating a lot of strife? That's a political science problem to some extent. That's why I don't have expertise on it. But to the extent that we actually make progress and learn how to cooperate, it's almost never because there were some people with power who made rules. In all societies, it's people who figured out how to interact peacefully and then got the benefit of that cooperation. Yeah,
I'm totally persuaded. And I think
okay, first of all, nobody's ever spoken to me and actually been totally persuaded. The best I can get is to stimulate thinking. But we have, I'm going to ask you
what I mean is I'm totally persuaded by the North Star aspect.
Okay.
That when you get into this situation where you have a nearly fully decentralized state of affairs where people are cooperating and there are the occasional frictions, and you figure out how to resolve the frictions through the accretion of precedent, good law, that sort of stuff. I mean, you even have discussed the idea that regulations can emerge from common law. Can you give an example of one of those?
Yeah, you're brilliant because that's where I was going to suggest we go anyway. Here's why. you began by talking about my book, Common Law Liberalism.
Mm-hmm.
And I would like everybody to read that book. But the book has two parts. And the first part, the way I describe the book, it has two theses, a moderate thesis and a more radical thesis. And the moderate thesis is that we would do much better in making public policy decisions if we didn't think of the choice as one between no regulation and government regulation, because common law is a regulatory entity as well. And so the moderate thesis is if you want to make good decisions, you should ask whether common law regulation works better than statutory regulation just to make a good decision. And a lot of the book argues for that. The second part of the book becomes more radical. The radical thesis is how far can we go without government functions? And that's sort of the anarchistic part of the book. So we've been spending a lot of time talking about the radical thesis, but the moderate thesis is a lot easier for people to understand. And I think has a kind of practical value that the more abstract one doesn't. So in this respect, I'm not, you said legal mind, philosophical mind, nothing like that is at work. I just have eyes. This part of
Tell me
my
about
book,
the more moderate thesis, if you don't
yeah,
mind.
okay, I'm not saying anything that's intellectually brilliant. And most of what I write can be summed up in two words, which is look around. So in our society, there's obviously a need for all kinds of regulation. We need regulation so people don't batter each other and harm each other and crash into each other. We need regulation on businesses so they don't do harmful things. We need regulation in order to live together peacefully in society. That's a given. I would never advocate a world with no regulation because that's the world that's in movies. I'm older, so it would be like Escape from New York or else The Purge or something like that. That's not the ideal society.
It's
What you,
externalizing the harms, the injuries.
yeah, what you want is a peaceful and a free and regulated society. And so the question is, what kind of regulation should you have? Now, if you just think about our society, there's two sources of regulation: plaintiffs, lawyers, and tort law, or politicians. Which form of regulation is more powerful? And we know the answer to that. Since businesses across the country are lobbying their state legislatures or the federal government for what's called tort reform, what they're telling us is tort law is the more powerful regulatory force. Right? Businesses can control the government. It can control the politicians. This year, having this conversation with you during the Trump administration, we just have to look around and see what's going on to see how obvious this is. So you can lobby the government and getting a subsidy for ethanol in the gasoline so that you can pay off farmers or something else like that. What's the one thing that businesses hate and they can't control, and there's nothing they can do to escape regulation? Who do they hate more than anybody else? These terrible, slimy, weaselly people called plaintiffs' lawyers. People who will sue them if they do anything that's dangerous or harmful. People who will sue them if they make the slightest mistake that could injure members of the public. And they'll come, if you buy off one of them with a settlement, the next one shows up. There's no escaping safety regulation from tort law, which is why they're lobbying the legislatures for tort reform, which is protection from regulation. We need regulation. Not only is there plenty of it in the society under the form of tort law, obviously there's too much because people are complaining about the fact that you can't do anything that's dangerous anymore. So,
or even just frivolous lawsuits. Like I had a friend who ran a business where you'd brush your teeth with charcoal, right? And they would take the charcoal and turn it into a powder, which made it processed. But he called it a natural tooth polish. It worked very well. And they did all sorts of independent testing on it to make sure that it didn't damage the teeth. Got dentists to look at it and use it. They liked it, but it was an old remedy, right? Well, in California, you can't anything that's processed can't say natural on it. So it's like, well, you might say, well, that's an artifact of statute, and I suspect that it is. But in the courtroom, there is no injury there to be resolved, or dispute to be resolved on whether and to what extent there was injury. So nothing like this would even appear before the court in your world. Is that more or less right?
No, anything that sounds perfect won't be something I advocate. Here, think about the implication. You started by saying there are a lot of frivolous lawsuits.
Right.
I assume that's true.
Yeah.
What's the implication of that being the case? The implication is we live in a society that is overly regulated, that there's too much regulation. If we're not only stopping everything that's really dangerous, we're even having lawsuits against things that are only marginally dangerous or that are truly frivolous, what that implies is we have too much regulation. If we have too much regulation, there can't be an argument that we need the politicians to create regulation. The argument is, where does regulation come from? From the common law or from the government? The argument for the government regulation is otherwise people will be free to do all kinds of harmful things. If there's already too much regulation without the government regulating, you can't possibly have an argument for government regulation. When the government regulates, what that means is the people who have the ability to capture the government can make laws that favor their interests, which is called rent seeking.
And you told me a minute ago that you weren't into the political science. I hear Buchanan and Tulloch on your shoulder a little bit there. So you've at least picked it up.
No, I picked it up. I got through. I think in the book somewhere I mentioned that I got through my college education without ever taking an economics course. And I got through law school the same way. And I came out with all these ideas. And then I met economists who said, oh, wait, they gave me the idea of trade-offs. I learned the compared to what thing. And just listening to a few economists made me realize that you don't be some kind of abstract idealist. You have to think about the way things actually work. So I picked up enough economics from listening to people where I can't do any math, but I know what trade-offs are. And I know that
Sure. Same.
the perfect is the enemy of the good. If you understand that, you've got a lot.
Yeah, it's really a shame because understanding rent seeking fully and public choice phenomena show you how power is basically on auction to certain interests and corporations, favor seekers. And this is how a lot of legislation is born and gets put in amber. So it's almost impossible to reverse.
The world speaks in riddles. Markets, politics, power, the very nature of consciousness itself. But what if there were guides, a secret fellowship dedicated to reading the signs, to building bridges between the seen and the unseen? The gray robes operate in the space others fear or cannot comprehend. We map the territory between spiritual awakening and practical revolution, between ancient wisdom and radical innovation. 12 dimensions guide us. One mission impels us. Find out more at grayrobes.org. That's grayrobes.org.
Honestly, this is sort of, if you look at this, let's call it the political science leg of the stool, where we have this legal leg and we have this philosophical leg. And I really like to lean on my philosophical leg, as is my wont. But then sometimes I'm sort of brutalized, mugged by reality with the political science part. Let's call it specifically the public choice phenomena, and how it leaves one with this almost political nihilism, like if this is unavoidable. If there's power to be auctioned off, it will be auctioned off. There will be a winner. They will hold that power. They will protect it, and you're not going to dislodge it.
You used an interesting adjective, and it's a good adjective. Political nihilism. If you see the world as the government makes the rules that we need for regulation, or there are no rules, then you're in this world where it is a nihilistic world, because you either have rent seeking or chaos. What's left out of that, and that's the way most people look at the world, what's left out of that is the non-political form of regulation that exists all around us. We should be political nihilists. There's no such thing as centralized power that's not used to favor the dominant interest over everyone else. That doesn't mean it's corrupt. People work hard and spend their life getting elected so that when they finally have power, they can do the right thing as they understand justice. They're completely ethically committed. They're still going to institute what they believe is the proper use of power, and unless everybody else agrees with them, it's rent seeking. It doesn't take corruption. It's built into the system. Political nihilism is the correct attitude. What you want to do is...
I guess the sense in which I was using that was more like how understanding public choice phenomena makes me feel hopeless.
Hopeless only if you're looking at government. What
Yeah.
it should do is say, government is hopeless. Don't be
Right.
hopeless, because we have an entirely other mechanism that has been functioning under the radar for centuries, which allows us to cooperate and have good rules. It's a common law system. And if you look there, you see all kinds of ways in which people can have rules that are actually coercively effective without rent seeking. The feature of the common law is it's rent seeking resistant. Here, I'll refer you to some work by Todd Zywicki, who does great work on economics of common law. But it doesn't pay to try to rent seek in the common law. If you spend lots of money to get some kind of corrupt bargain made through a lawsuit, then the next person who comes along might get a different result. I mean, there's no reason to invest a lot to get common law rules which are unstable. What you want to do is you want to invest in the politicians who will make a statute which can't be changed and which favors your interest in the long term. If you're worried about rent seeking, then you're on my side. What we need is a common law system.
Absolutely. And I'm going to leave you with this last question. Without having the satisfaction of figuring out how to reverse public choice phenomena that put us in this unholy alliance between corporation and states where favor seekers win and the rest of us lose, and you get this sort of Mansur Olson concentrated benefits dispersed cost thing that seems irreversible. But let me close with this question, at least an appeal to your inner idealist and the one who, as you put it, just looks around, right? And that is this: at one point in your career, you made the case for anarchism, the A word. Do you still wear that scarlet letter in any sense?
Yes. The right way to organize a society is without government. It's not without governance, it's without government. The right way to organize a society, if I could have the power to magically change things, would be to have rules that evolve and govern and allow people to cooperate and keep centralization of power and rulemaking ability as far removed or completely off the table. Now, having said that, that's a philosopher's answer, because how do you stop people from gaining power and using it to undermine what would otherwise be a stable, peaceful system? I don't have a particularly good answer for that. History seems to be, it's a little bit like markets. Markets go up over time, but not evenly, up and down in an upward trend. If you have enough people trying in enough places, I'm hoping that over time we move in the direction of less power and more freedom. Now, right now, we're in a real low. The idea that the Bill of Rights, that the Constitution, that even the statutory law means anything anymore, it almost doesn't exist. But I'm hoping that something will happen. You know, I'm old now. When I was a kid, we were faced with McCarthyism, and that was a dark time. And yet some people stood up and fought it. By the way, McCarthyism is one of my favorite things, because the thing that stopped the blacklist was a tort lawsuit brought by one man and one lawyer, which broke the blacklist, not anything from the government. The government was enforcing the blacklist and publishing all kinds of things about who you should go out and try to shame and suppress. But that was a dark time. And yet it led to at least a short time period where things moved in a more liberal direction. I see no reason for hopefulness now, other than where we are now is either going to go all the way down, or it's going to cause something that might be an analog of what happened in the early 1960s, and people will move in a liberal direction again. And the advance of technology, the advance of things that allow us to cooperate, and we don't have to remake the common law of commercial law, it already exists. If we can peel away the abusive powers, things will start generating again. You know, we have such a powerful engine of prosperity that's being suppressed now. If we just somehow could free it, we could make amazingly fast progress again. But again, we have way too much democracy. That's the problem. People can vote. I don't believe in democracy. I don't believe that if enough people say you should have power, that's a good reason for giving them power. And our system has degraded into a democracy instead of a limited government with all kinds of restrictions. If somehow we could do something that shrunk government power, you know, after Nixon, for a short time period after Nixon, Congress actually tried to restrict presidential power. That was important. It didn't work for very long, but that was important. If a miracle occurs and a modern day analog of Ronald Reagan comes along and gets elected president and then convinces the Congress to shrink executive power, then things may be better. This is sort of rose-colored glasses. But that's all I have to offer.
And shrink legislative power too.
Yeah, that's true, but one step at a time.
One step at a time.
Because it's hard for the legislature to do things, right? The government's closed right now because it's hard to get the legislature to do things. That's what's good about legislative power. It's decentralized. So first, you stop presidential power, and then you worry about legislative power as well.
Amen. Amen. Professor Hasnas, thank you very much for joining us today. It has been an absolute pleasure.
All right, well, thanks very much for the conversation.